Record in cause number 24105-25-21, State versus Jordan. Hawkins on indictment charged with first degree felony, aggravated robbery. Defendant is present before the court by Zoom. Defense counsel, Mr. Perkins, is present before the court on Zoom. State's counsel, Ms. Altry, is present before the court on Zoom. All right. Ms. Altry, is your recommendation on the first degree felony with a sentencing range of not less than 5 to 99 years of life, 10 deferred, aggravated robbery?
That is, Your Honor. This is a case that Mr. Perkins worked with Mr. Chamness on. Other defendants that were co-defendants in this case. Mr. Hankins, as you can see, is a very, very young man. He was born in 2000. This is his first felony. Unfortunately, he chose to go the big route, but that's one of the reasons why Mr. Chamness is giving him the opportunity to do the full amount of deferred on this case. And then if he knows if he messes up at all,
Well,
He
I
is looking at the range of punishment.
know. What I'm talking about is why is the state recommending? I may have a good reason. Maybe I need to look at the reports that you're looking at. My question really was, didn't mean to cut you off. I apologize. What's the basis for the state recommending only the defendant's young? I have the indictment here, obviously, trying to get to the reason the state's is recommending on a first-degree felony aggravated robbery where the defendant is charged by an indictment with intentionally, knowingly, and threatening placing Raphael Mojica in fear of imminent bodily injury or death, and the defendant did then there use or exhibit a deadly weapon, namely a firearm. I was trying to sort of get a little understanding of why this recommendation was being made by the state.
Correct, Your Honor.
I can look at him and see he's young. Send us young defendants penitentiary all the time. Go ahead.
Yes, Your Honor, and Mr. Perkins can correct me if I'm wrong, but out of the co-defendants, Mr. Hankin was not the most culpable. It was also a BB gun that was used in the offense. And
let me ask you right there, how many co-defendants are there?
There's Mr. Hankins, there's a gentleman named Dietrich Martin and a Nathaniel Simon.
Have the other two been adjudicated or pled or what?
I can double check that right now for you.
The most culpable one, Judge, I'm not sure his case is even in this particular court, but I know that the other, I'd like to think that Mr. Hankins is the least culpable, but I would say the next least culpable one got a similar deal.
Well, normally all co-defendants, I don't know what you're saying. I'm going to just let me double check on that, Mr. Perkins, to see where the other, of course, Jordan Hankins was right here on Zoom before us, George, for the aggravated robbery. Do you have the two co-defendants on there, Tab? What are their cases if they're not here?
They're in the 241st, Judge.
So
One, Nathaniel Simons is in the 7th. Dietrich Martin is in your court, Your Honor. And he received 10 years deferred probation as well. As far as Nathaniel Simon, who is in the 7th, I can look and see if his case has been resolved yet.
Well, why are they, well, two of them are in here. Is the other co-defendant here? Is his case been resolved?
It seems like, Judge, it seems like he got resolved for a 20-year sentence.
Okay.
That's correct.
Okay, so what was his name?
Nathaniel Simon.
So Nathaniel Simon apparently pled in a plea agreement, got 20 years, I'm sure, with the front you find of deadly weapons. That you looking at it?
Yes, Your Honor. And there was an affirmative finding of a deadly weapon.
Okay.
But just like Mr. Perkins said, out of the three, Mr. Hankins is the least culpable. And again, the other one that was like next up on the culpability ladder, for lack of a better term, was Dietrich Martin, who was in this court under 241-1974-20, and he received the same offer and accepted that offer of 10 years deferred probation.
In this court?
In this court.
Do we get a pre-sentence on him?
That,
Can you tell?
I don't think so, Judge.
Okay, well, I don't know which prosecutor represents the state of the plea. I would think the court would have had some idea about the facts of the case.
right. It was Mr. Chamness, Your Honor.
Okay, well, all right. So Mr. Chairman, represents the state on the other plea that the court followed with the recommendation for 10 deferred.
Yes, Your Honor.
All right, did I get Mr. Hankins sworn in?
No, Your Honor.
Raise your right hand, Mr. Hankins. You solemnly swear the testimony you'll give by Zoom before the court will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, Your Honor.
Mr. Hankins, I'm sure you have been over this indictment charging you with aggravated robbery, first degree felony, with your attorney, Mr. Perkins, so you understand all the allegations, the charge in the indictment, and the full range of sentencing. Is that correct?
Yes, Your Honor.
I've also got a set of plea documents in front of me. I don't know whether or not they're going to be going up on the screen, but I'm going to go through and identify them. They're all signed actually by printed signature, which that's as good as a signed one, printed on each plea paper above where it says defendant is Jordan, Jordan, Hankins, Hankins. Is that going to be your printed signature on the line above where it says defendant on each plea paper, Mr. Hankins?
Yes, Your Honor.
It's also signed, of course, by Mr. Perkins and also signed by Ms. Autry on behalf of the state. So you understand the state's recommendation, if you plead guilty, the state's going to recommend 10 years to deferred adjudicated probation. You understand that?
Yes, Your Honor.
You understand if I place you on deferred adjudicated probation following the state's recommendation, and if any time while you're under deferred adjudicated probation, which can be up to 10 years, if the state files a motion to adjudicate your case, it would allege violations of your deferred adjudicated probation by you, that would immediately trigger a no bond warrant. Do you understand that?
Yes, Your Honor.
I mean, you understand you'd be before a judge, and the judge would be hearing evidence. It would not be a jury trial. The judge would hear evidence, and if the judge was convinced from the state's evidence you had in fact violated one or more conditions of your deferred adjudicated probation, then the judge can, number one, go back and find you guilty of the offense of aggravated robbery. Then because you were on deferred, the judge can assess your sentence up to 99 years or life, and the Texas Department of Corrections fined it up to $10,000. You understand all that?
Yes, Your Honor.
But I'm going to need to go over these plea documents with you. I don't know, they may not be up on the screen, but if you have obviously, you've signed them, and now signed or sworn to them. Mr. Perkins has signed, the state's attorney's signed them. So I think it's safe to say that you would have gone over all these plea documents with Mr. Perkins, your attorney, so he would explain all the plea documents to you, so you understood what you were signing or signing and swearing to. Is that correct, Mr. Hankins?
Yes, Your Honor.
What your plea document is, being a plea of guilty to the indictment, state's counsel is going to recommend your sentence of 10 years deferred adjudicated probation. That 10 years deferred adjudicated probation will be ordered, with restitution if that has been or can be determined to be due. Do you understand the plea agreement?
Yes, Your Honor.
You understand if the court follows the plea agreement, places you on 10 years deferred adjudicated probation, you'll have 70 or so terms and conditions. If any time while you're on that 10 deferred, which can be up to 10 years, the probation department sends the judge of this court what we call a violation report, telling the judge that in the probation officer's opinion, you have violated one or more conditions of your deferred adjudicated probation that will trigger a no bond warrant for your arrest. You understand that?
Yes, Your Honor.
Once you turn yourself in or you're apprehended, there would be a motion to adjudicate hearing before the judge this court. If the judge, not a jury, if the judge determines from the evidence you had violated one or more, it only takes one, conditions of your deferred adjudicated probation, the judge can grant the state's motion to adjudicate. That's just a big legal word, meaning the judge would go back, finds you guilty of this aggravated robbery as charged in the indictment. That's a first degree felony. So the judge could sentence you up to life in the Texas Department of Restitutional Division, fined up to $10,000. Do you understand that?
Yes, Your Honor.
You understand the first paragraph of the indictment obviously charges you with the offense of aggravated robbery, carrying that 5 to 99 years of life sentencing range. The second paragraph, which is contained within your stipulation of evidence, alleges that you used or exhibited a deadly weapon with a firearm, but in the manner and means of its use and intended use was capable of causing death or serious bodily injury during the commission of or immediate flight from said offense. That can be as the primary actor or as a party. But do you understand if we finish the plea and the court receives and accepts the recommendation and the court follows the recommendation, places you on 10 years deferred adjudicated probation, the court will make an affirmative finding to which you stipulated to in the second paragraph of the indictment that you used or exhibited a deadly weapon as charged in the indictment. That'll be on the front of the judgment. That's finding by the court. Do you understand that?
Yes, Your Honor.
Well, if you get down the road and you violate, I'm sure Mr. Perkins has told, I don't know if he's told you all this, but if you get down the road somewhere and you violate any of your 70 or so terms and conditions of your deferred adjudicated probation, and the state files a motion to adjudicate alleging those violations of your deferred, and no bond warrant goes out, you end up before a judge, sitting where I'm sitting right now, not a jury trial. If the judge finds you have violated from the evidence any term or condition, it only takes one of your deferred adjudicated probation, the judge can grant the state's motion to adjudicate, and the judge would go back and find you guilty of the offense of aggravated robbery, a first degree felony. The judge would look at the judgment and see that the court has made an affirmative finding that you used to exhibit a deadly weapon, as alleged in the second paragraph of the indictment, the final one. And then whatever sentence the judge assessed you for 5 to 99 years or life, because it can be up to life, 5 to 99 years life, the judge would tell you that, again, the judge would make an affirmative finding you used to exhibit a deadly weapon. You understand the effect that has on mandatory time?
Yes, Your Honor.
You get sent to the penalty. I'm sure Mr. Perkins has told you. I'm just trying to emphasize with you, everything you're saying is being transcribed. So I always try to make sure you understand on a motion to adjudicate that if the state, in other words, if the state believes you violated any of the conditions, they file a motion to adjudicate and no bond warrant goes out, hearings held before a judge, not a jury, and the judge finds you have violated one or more conditions of your deferred adjudicated probation, the court will grant the state's motion to adjudicate. That's just a big legal word, meaning the judge will go back and find you guilty of the offense of aggravated robbery or first degree felony. And then the judge, it's not a jury, the judge can assess you the maximum if the judge feels it's appropriate, up to 99 years of life in the Texas Department of Corrections, and that affirmative finding of deadly weapons, which affects your parole eligibility date, will be in the judgment. I'm sure you understand all this from Mr. Perkins. Is that correct?
Yes, Your Honor.
All right, the first document I've already said is the agreed punishment recommendation. If you enter a plea of guilty to the indictment, which would follow the state's recommendation, withhold the finding of guilt, place you on deferred adjudicated probation for a period of 10 years. That's your plea agreement. Do you understand it?
Yes, Your Honor.
These are all plea documents you signed, and I know without asking about for the record, you did go over all this Mr. Perkins stuff, what you were signing and swearing to on the plea documents, correct?
Yes, Your Honor.
There's an acknowledgement of admonishments, all these are signed, short signed. And when I gave you that oath, you understand that when you have sworn to tell the truth, within that oath, you're also swearing that you are swearing to, you're telling the court, you're swearing to all these plea papers under oath today, and that all the plea papers are true and correct. You understand that?
Yes, Your Honor.
All right, so we've got the acknowledgement of admonishments, which are signed by you and by Mr. Perkins. It shows you the full range of sentence, in fact, community near 99 years of life. You receive up to maximum if a judge adjudicates the case, finds you guilty for violations of your deferred. Then the judge can assess you up to the maximum. You understand you're waiving giving up your right to a jury trial.
Yes, Your Honor.
You're agreeing to the court. You're agreeing to the court hearing the indictment today without a jury. Is that correct?
Yes, Your Honor.
And then you also signed and sworn to now a waiver of confrontation with witnesses and agreement to stipulate evidence. So you understand the stipulation of evidence signed and sworn to by you. That is a written judicial confession, and you understand it would be correct. You're not only signed it, you're swearing to it now under oath, freely, intelligently, knowingly, and voluntarily. Is that correct?
Yes, Your Honor.
You understand that stipulation of evidence states too is a written judicial confession issued by you under oath to all of the allegations of the charge in the indictment. You with me on that?
Yes, Your Honor.
You understand that?
Yes, sir. Yes, Your Honor.
There's an agreement to stipulate testimony. There's a form for a waiver of appeal, waiver of right to file a motion for new trial. There is a waiver of the pre-sentence, which is already done. There is a trial court certification of your rights to appeal, already signed by you and Mr. Perkins. The court will check that. It'll say, the court will check forward where it says this is a plea bargain case and you have no right of appeal. And it will say, also be checked where it says you have waived giving up your right of appeal because you filed the document waiving giving up your right to appeal. Do you understand all this?
Yes, Your Honor.
Well, the only other document I've got is a certification for you on advice you received from Mr. Perkins. Understanding the allegations and the charge in the indictment for aggravated robbery, the second paragraph alleging the use or exhibit a deadly weapon with a firearm, and understanding all these plea documents, do you still wish to go forward on your plea of guilty to this indictment today without a jury?
Yes, Your Honor.
All right, here are the questions. Tell me if you don't understand any of them. They're pretty straightforward. Do you read, write, and understand English?
Yes, Your Honor.
Have you consumed any alcoholic beverage in the last 24 hours?
No, Your Honor.
Were you under the influence today of any type, drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, Your Honor.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, Your Honor.
Do you understand everything you're doing in court today?
Yes, Your Honor.
Have you been over everything about in all these plea documents you signed or signed and sworn to with Mr. Perkins?
Yes, Your Honor.
Have you been over everything about the facts of your case with Mr. Perkins?
Yes, Your Honor.
You've been over the indictment and the charge and the allegations in the indictment with Mr. Perkins, correct?
Yes, Your Honor.
You confident, Mr. Perkins?
He is, Your Honor.
He has some confidence or something.
No, Your Honor.
What States Council signed her consent, put the waiver of trial by jury, put the waiver of trial by jury, all the other waivers of the case signed, to by the defendant. All right, then, Mr. Hankins, you do understand all the allegations, the charge in the indictment, the full range of sentencing, your plea agreement, and all these plea papers. Is that correct?
Yes, Your Honor.
Do you have any questions for me?
No, Your Honor.
All right, in clause number 24105-25-21, what is your plea today to the indictment charging with the offense of aggravated robbery or first degree felony as alleged in the indictment?
Guilty, Your Honor.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, Your Honor.
Has anyone threatened you in any way, promised you anything, or coerced you, made you plead guilty?
No, Your Honor.
Are you entering your plea of guilty to the indictment today because you have any type of delusion in your mind or some type of unrealistic hope of pardon, parole, or leniency?
No, Your Honor.
All right, the court does receive and accept your plea of guilty to the indictment, finds it was entered freely, intelligently, and knowingly, and voluntarily. Court does at this point withhold the finding of guilt. Go ahead, Ms. Hall.
We would offer states 1, the plea packet with signed waivers and admonishments. States 2, the signed and sworn to stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection to the
No,
exhibit
no
marked
objection.
and offered, Your Honor.
Thank you, Mr. Ferguson. No objection. The court approves and admits into evidence states 1 who will sign or sworn to plea documents. Signed or sworn to by the defendant, signed by his attorney, identified on the record by the court. States 2 is to sign or sworn to with stipulation of evidence. States 2, the written judicial confession to the allegations in the indictment by the defendant under oath. States 2 is approved by the court, committed into evidence with no objection. States 3 is discovery compliance, approved, admitted into evidence in stage 3. The court finding the defendant's waiver of his rights execution of all the other documents, the plea documents on the plea, were all done by the defendant freely, intelligently, knowingly, and voluntarily. And the court finds all the plea documents signed or sworn to by the defendant for purpose of the plea were all done freely, intelligently, knowingly, and voluntarily. The court, having received and accepted the defendant's plea of guilty, finding it was entered freely, intelligently, knowingly, and voluntarily, having admitted into evidence, and I do have states 1 and 2 in, correct?
Correct, Your Honor.
States 1 and 2 include the stipulation having been admitted in. The court in this case does withhold a finding of guilt. Will proceed to sentencing.
We would offer states 4, an electronic copy of the written discovery in this case.
No objection, Your Honor. We've previously received a copy of that.
All offensive investigative reports are admitted into evidence. Anything else, Ms. Alter?
No, Your Honor.
Anything else, Mr. Perkins?
No, Your Honor.
According to this case, then, based upon the defendant's plea of guilt to the offense of aggravated robbery of first degree felony, evidence presented and admitted into the record by the court. The court does find the evidence in the record on the defendant's plea of guilty to the offense of aggravated robbery to be fully sufficient to support the defendant's plea of guilty to the offense of aggravated robbery as alleged in the indictment. However, the court does withhold a finding of guilt as to the defendant for the offense of aggravated robbery and withholding a finding of guilt. The court follows the plea agreement, the recommendation of the state with the evidence admitted in by the court. The court, following the plea agreement, the state's recommendation assesses the sentence at 10 years, deferred, adjudicated probation, no fines assessed. Court calls for to pay. Is any restitution due?
Your Honor, that I am not aware of. We would ask for a post-sentence to be ordered just on restitution.
Court order post-sentence myself and probation department supervising officer to determine what amount of restitution is due. If there is any restitution due, it's ordered to be paid by the defendant. I'm sure it's already been ordered to be paid if there is any about co-defendants. Anyway, it's ordered to be paid by this defendant, the amount to be due as a term and condition of the deferred adjudicated probation. Court, to having received and accepted the defendant's plea of guilt and finding the evidence in the record fully sufficient to support the defendant's plea of guilt, court withholds the finding of guilt, falls the plea agreement assessed to the sentence of 10 years, deferred, adjudicated probation, no fines assessed, court costs will be paid. Restitution is ordered as term due by post-sentence. Sentence is formally pronounced. A defendant's waiver giving up his right to appeal, defendant's waiver giving up his right to file motion for trial are noted, made a part of the record in the case. Now, you understand, Mr. Hankins, on that 10 years deferred adjudicated probation, if you serve that out, obviously the 10 years deferred adjudicated probation and do not violate any of the terms and conditions, the state then would dismiss the indictment against you. You would not have a conviction for this offense of aggravated robbery. Agree with me on that?
Yes, Your Honor.
The other side of the road is on deferred adjudicated probation. If any time while you're on this deferred adjudicated probation, if the judge of this court receives a violation report from your probation officer telling the court that you have in fact violated one or more conditions of your deferred adjudicated probation, that will immediately trigger a no bond warrant for your arrest. Once you are arrested or turns yourself in, the judge of this court would conduct what we call a hearing on the state's motion to adjudicate, because the state would have filed a motion alleging violations of your deferred adjudicated probation, which would trigger a no bond warrant. At that hearing, before the judge, there would not be a jury. If the judge was convinced to the level required by the law that you had in fact violated one or more, only takes one, that you had in fact violated one or more conditions of the deferred adjudicated probation, the judge would go back, grant the state's motion, the judge would adjudicate the case. The legal word, which means the judge would go back and find you guilty of the offense of aggravated robbery as alleged in the indictment. And then there is an allegation in the indictment that you used to exhibit a deadly weapon, a firearm. I'm going ahead and making that finding it'll be on the front of the indictment. So if you get in on a motion to adjudicate because you fail a drug test, fail a report, or violate any of your other terms and conditions of the state, this motion to adjudicate is granted by the judge. The judge will go back, finds you guilty of aggravated robbery, first-degree felony. The judge will see the affirmative finding on the judgment that I'm going to make, and then making now that you use for exhibit a deadly weapon as alleged in the indictment, a firearm, and then either myself or the next judge considering the motion to adjudicate, if the judge finds violations alleged by the state, the judge grants the motion to adjudicate, finds you guilty of the offense of aggravated robbery as charged in the indictment, and then the judge can assess your sentence between 5 and 99 years of life in the Texas Department of Corrections. In other words, the judge can sentence you to a maximum of 99 years of life in the Texas Department of Corrections. In addition, the sentencing judge will make an affirmative finding that you use for exhibit a deadly weapon because it's going to be in and on the judgment assessing you the deferred adjudicated probation. Do you understand all this?
Yes, Your Honor.
How old are you, Mr. Hankins?
21.
21 years old. I cannot emphasize enough to you the importance. I'm sure Mr. Perkins has told you the same thing. Your probation officer you're assigned to, I don't know who that'll be, but your probation officer is going to emphasize over and over to you the importance of closely following all your terms and conditions of your deferred. There's about 70 or so of them, and your probation officer is going to go over to all of them with you. Because if you violate any of those terms and conditions of your deferred, fail to report, fail a drug test, or fail any of your other conditions of your deferred, it'll trigger that no bond warrant. Then you'll be sitting down here in front of this court looking at the judge. And the judge, if the judge finds, not a jury, that's what I'm trying to emphasize to you, if the judge finds you violated one or more conditions of your deferred, the judge will grant the state's motion to adjudicate. Adjudication is a legal word meaning the judge will find you guilty of the offense, back, fatal, wrongful, first degree felony, and the judge can sentence you up to 99 years of life. Do you understand that?
Yes, Your Honor.
I know Mr. Perkins has emphasized this to you. But you gotta be real careful. And report, and that's all your drug tests, and listen closely and follow the instructions of your supervising probation officer. When you book, Marcella, go ahead and explain to him what he has to do when he eventually books out of jail.
Yes, Your Honor. Mr. Hankins, as immediately upon being released from jail, immediately report to the Smith County Probation Department. When you get to the probation department, sign a new from court. Our intake officer will come and get you from the lobby and assign you a supervision officer. If you're released after 5 p.m. today, then we'll see you tomorrow at the probation department at 8 o'clock in the morning.
Okay. Did you hear the court's probation officer?
Yes, Your Honor.
When are you supposed to report?
To the probation office?
That's where you're supposed to report, to the probation office. Walk in the front. Do you know where the probation office is? Let's be sure he knows where to go, Marcel.
Yeah, on Line Street.
Yes, we're located on 217 East Line Street.
Yeah, Line Street.
Okay, you know where 217, you know where East Line Street is. The address is 217 East Line Street. If you did any, and I'm sure you did some pre-trial drug testing and reporting, it's the same office. You know what I'm talking about?
Yeah, yes, Your Honor.
Okay, well, hope so, because well, if you look out before 5 o'clock today, that's very unlikely. It's 10 after 4, but theoretically, if you did, you'd have to go down to the probation department immediately from the jail. More likely, you'll book out sometime after 5, maybe even in the morning. But if you book out after 5 sometime this evening, as Marcella said, I have a reason to emphasize this to you. You book out sometime this evening after 5, you have to be in your probation officer's office at 8 o'clock a.m. in the morning. Are you with me on that?
Yes, Your Honor.
Okay, what happened is that, you gotta get up, get out of the sack, get both feet on the floor, and get the heck to the probation department at 8 o'clock if you book out after 5. So if you're not sitting in the office at 8 o'clock, they'll know when you book out by the computer. If you book out tonight at 8 o'clock, let's say, it'll be on their computer, and they'll be expecting you at 8 o'clock in the morning. If you're not in their office at 8 o'clock in the morning, you book out after 5, they're gonna fire off to me a violation report, and I will sign a no bond warrant for your arrest. And the state will follow up with a motion to adjudicate. It can just be based on your failure to report. Anytime you don't report as ordered, it's a violation of your probation. You understand all this?
Yes, Your Honor.
You understand the reason I'm trying to emphasize all this to you?
Yes, Your Honor.
Because at your age, 99 years or life on a motion to adjudicate with an affirmative finding is a bunch of time, bunch of years in jail. You with me?
Yes, Your Honor.
You'll actually be in prison. And you'll be in prison unless a judge, for some reason, you can be on the motion to adjudicate, I'll put it this way, you can be in prison up to 99 years or life with this affirmative finding. It's very important you pay close attention to all of these conditions. I know the state representative Bird, you haven't been involved in anything like this before. I'm just trying to emphasize on you as your probation officer, well, how important it is to follow the conditions. If you end up in the penitentiary for 30 or 40 years, you would believe then it was important. I'm trying to be sure you believe now. Okay?
Yes, Your Honor.
Do you have any questions?
And Judge, I stressed to him the importance of him being in the probation department tomorrow at 8 o'clock. I gave him the same warning that you did about the importance of him showing up at 8 o'clock in the morning. But just so there's no confusion, I thought, at least the way I heard, Marcella told him to be there at 10. So
Well, you know, here's the deal, Mr. President, it may have changed. I'm used to saying 8, but obviously I'm not the probation officer. He needs to go with what Marcella just said. I'm sorry, Marcella, did you say 10?
No, Your Honor, I said 8 o'clock in the morning.
Okay, I'm just making sure I heard it right.
Well,
Okay,
it's normally always 8 o'clock in the morning.
that's what I had previously told him, to be there at 8 in the morning. But I doubt seriously that he would get booked out in the next hour.
Yeah, yeah, your odds of coming out in the next hour are low, but if you do, it's before 5, you gotta go straight to the probation officer and these lines straight. If it's 4 o'clock, because you're a probation officer. This felony probation officer will be looking at a computer, she'll know, or he'll know when you book out. Do you understand the importance of following these terms and conditions?
Yes, Your Honor.
You understand what the maximum is you can violate? If you violate it, say you fail a drug test, fail a report, and they'll file a motion to adjudicate, no bond, one will go out, be heard by a judge, not a jury. What's the maximum you can get? If you violate a term or condition of this deferred on a motion to adjudication, the legal word, in the state convinces a judge you have violated one or more conditions of your deferred, the judge will go back, adjudicate the case, just a big legal word, meaning the judge will find you guilty of aggravated robbery with a deadly weapon. What's the maximum penitentiary you can get? And that's not a jury trial, it's before a judge. Can you hear me okay?
Oh, what'd you say, Your Honor?
Well, here's, okay, let me be sure you understand this, because I thought you did. I have a reason for telling you at your age, you don't have some lengthy history. You haven't been down there before. At your age, with no history, you just need to be sure you follow these terms and conditions. If you book out, you already know from Marcella, the odds are you'll book out after 5. You have to be sitting in the probation department on these lines straight at 8 o'clock in the morning. You got that one?
Yes, Your Honor.
You understand, like Mr. Perkins was asking you, has a reason. Do you understand that if you violate any of the terms and conditions, you can receive up to 99 years of life in detention?
Yes, Your Honor.
Do you have anything else to say to him, Mr. Perkins? I'm about out of the wind.
I don't have anything else, Your Honor.
Marcella, you have anything else?
Yes, Your Honor, that he avoid contact with the victim in this case and avoid contact with the co-defendants.
Your probation officer will go over that term and condition with you. One of your specific terms and conditions is you cannot have any contact with the victim in this case. That would be the individual who was the victim in the aggravated robbery committed by you and apparently two of your partners or whatever. You can, and when I say no contact, that means you cannot go within 1,000 feet of where that individual is, and you cannot have any contact with that individual by cell phone, Twitter, Facebook, or any of that other electronic stuff. You with me on that?
Yes, Your Honor.
And you cannot have any contact with any of the co-defendants. I'm sure you're aware of the 2 individuals that participated in aggravated robbery with you. One of your conditions of your deferred adjudicated probation is you cannot have any contact with either one of those 2 individuals. It's the same instruction there. Any contact means you cannot be within 1,000 feet of where either of your co-defendants are located, and you cannot have any contact with either of your co-defendants by any of these electronic devices I've been talking about, Twitter, Facebook, obviously texting. Are you with me on that? It's real important.
Yes, Your Honor.
Okay, you have any questions for me about anything?
No, Your Honor.
Contact with any of your 2 co-defendants is any type of contact with them can land you in the penitentiary for up to life. You with me on that?
Yes, Your Honor.
Do you believe it can happen if you violate your conditions of your deferred probation, that you can end up in the Texas Department of Corrections for life with an affirmative finding that you used to exhibit a deadly weapon?
Yes, Your Honor.
Okay, you believe it, so you need to bear down on it. You're at an age where you're going 1 of 2 ways. And if you go the wrong way, it'll be a while before you breathe fresh air. You understand why I'm saying that?
Yes, Your Honor.
Okay, I don't have anything else to tell you. I don't know whether it'll be me or the next judge you should violate. I can't speak for the next judge. I'll be about the same thing. So, anything else, Mr. Perkins?
No, Your Honor.
So you do understand when you book out the instruction reporting, correct?
Yes, Your Honor.
Do you have any questions for me?
No, Your Honor.
All right, that's it for me, Marcella. We're in recess, counsel. Defendants continue in the custody of the sheriff till he reports to probation. Thank you, Mr. Perkins.
Thank you, Judge.
You Judge.
You need to take your mask off. You
They can hear me?
Yes.
Okay.
Only one. State versus Roderick, R-O-D-E-R-I-C-K, Bordeaux, B-I-R-D-O-W. Charged by an indictment with a second-degree felony offense of robbery. He's present on Zoom before the court from jail with his attorney, who is obviously Mr. Cargill. He's present by Zoom before the court. State's counsel is present before the court. Ms. Altrin, of course, the probation officer is present before the court. All right, Mr. Bordeaux, raise your right hand. I have to swear you in on your plea. Do you solemnly swear your testimony will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Bordeaux, are you waiving the reading and formal presentation of the indictment, counsel, and all the other formalities, Mr. Cargill?
Yes, Your Honor.
All right, Mr. Bordeaux, first of all, Mr. Bordeaux, you do understand all the allegations and the charge in the indictment. Is that correct?
Yes, sir.
You understand part of the allegations, the last paragraph reads that obviously Smith County, the state of Texas, but you, Roderick Bordeaux, did then and there while in the course of committing theft of property and with intent to obtain or maintain control of the property, intentionally, knowingly, and recklessly caused bodily injury to Danelia Leon by dragging Danelia Leon with a motor vehicle against the peace and dignity of the state. Do you understand those are the allegations?
Yes, sir.
Do you understand this is a second-degree felony? I'm going to follow the state's recommendation, which the state's recommended 7 years deferred adjudicated probation, which means if you do plead guilty, the court will hear the evidence on the plea of guilty, then I would withhold the finding of guilt, place you on 7 years deferred adjudicated probation. Your first condition when you book out of jail would be to report directly to the probation office. We'll get to that. But do you understand if I follow the recommendation, I place you on 7 years deferred adjudicated probation. If any time up to 7 years while you're on the deferred, you violate any term and condition of your deferred adjudicated probation, then no bond warrant, just on the allegation, a report filed by the probation department stating the violation the probation department believes you committed, not reporting, failing a drug test, or any of your other 70 or so terms and conditions, that triggers a no bond warrant. Then when you're arrested or turned yourself in, there's a hearing held before the court on the state's supposed to adjudicate. It is not a jury trial. Do you understand that?
Yes, sir.
It is a hearing before the judge. If the judge will hear evidence, and if the judge is convinced from the evidence you have violated any of your 70 or so conditions of your deferred adjudicated probation, the judge will grant what's called a motion to adjudicate, find violations of your deferred adjudicated probation, and then the judge will go back and find you guilty of the offense of robbery as alleged in the indictment. That's a second-degree felony, 2 to 20. Because you were on deferred, that judge, either this court or the next judge, who grants the state's motion to adjudicate because the evidence convinces the judge you have violated terms and conditions of your deferred, the judge will find you guilty of the offense of robbery, and because you were on deferred, the judge can assess your sentence up to the maximum 20 years in the Texas Department of Corrections and a fine of up to $10,000. You understand that?
Yes, sir.
Now, I've got this set of plea papers. They're all signed by signature. I can easily read Roderick Bordeaux, but I have to ask you, is that your signature, Mr. Bordeaux?
Yes, sir.
When you signed and swore these plea papers, did you go over them all with your attorney, Mr. Cargill, so you understood what you were signing and are signing and swearing to?
Yes, sir.
So you understand your plea agreement is, and the court's going to follow it. Based on the state's recommendation, I'm going to withhold the finding of guilt, find the evidence sufficient to support the finding of guilt, but I'm going to withhold it and place you on deferred adjudicated probation for a period of 7 years. Do you understand that?
Yes, sir.
All right. Is that your recommendation, Ms. Altry?
Yes, Your Honor, this is a case that Mr. Cargill dealt with Mr. Chamness on, and his recommendation is for the 7 years deferred as well as a post-sentence investigation for restitution.
Okay, is that it, Mr. Cargill?
That is, Your Honor.
All right, now, Mr. Bordeaux, so that's your plea agreement. Do you understand your plea agreement?
Yes, sir.
All right, I'm going to identify these other plea documents. They're all signed by, I can easily read your signature. They're all signed Roderick Bordeaux. That's going to be your signature on all the plea documents. You signed all the plea documents, correct?
Yes, sir.
All right. Some of them show they're sworn to. You understand now in that oath, you've not only signed them, but you've sworn to them. You understand that?
Yes, sir.
Okay, do you understand? I'm going to go through them one by one. There's an acknowledgement of admonishments. It gives you the sentencing range 2 to 20. It's real important to you. It's always important, but when you're on deferred, the maximum is important because if you violate the deferred, a judge will hear the violations, and if the judge is convinced the violations occurred, the judge will go back, he or she'll go back, finds you guilty, and the judge is going to assess you 20 years in the Texas Department of Corrections Institutional Division. You understand that?
Yes, sir.
Well, I've got these papers. Of course, there's a trial court certification. It shows it's a plea bargain case. It also shows it's waived your right to it. You've waived your right to appeal. The plea papers I've got in front of me, they're a little bit out of order, but I've got an advice you signed where you basically understand your rights to appeal and you're waiving, giving up your right to appeal at this time. Do you understand that?
Yes, sir.
Okay. Now, also, you're requesting a waiver of the pre-sentence. That's approved. You're waiving, giving up your right to appeal also by one of the documents. That same document waives and gives up your right to appeal. You understand all that, Mr. Bordeaux?
Yes, sir.
It's done an agreement to stipulate testimony. Well, the agreement to stipulate testimony is the next document on the plea. The stipulation of evidence states too. That stipulation of evidence is a little bit hard to see on the computer, but the stipulation of evidence signed and sworn to by you, signed by your attorney, that is a written judicial confession under oath by you to all the allegations of the charge in the indictment for robbery, a second-degree felony. You understand me on that one?
Yes, sir.
You signed and now sworn to a waiver of confrontation and agreement to stipulate testimony. Of course, you understand you're waiving, giving up your right to a trial by jury. You understand that?
Yes, sir.
And I've got these admonishments that are in a document that's signed by you and Mr. Bordeaux. There's 7 of them. Now, you understand you're waiving and giving up your right to a trial by jury at this time. You're agreeing to go forward on your plea of guilty, apparently to the indictment, based on the evidence that'll be admitted in. One of them is that stipulation of evidence where you admit the offense. You following with me on all this, because I'm getting ready to ask you some questions. So you understand
Yes,
everything so far? You understand everything so far?
Yes, sir.
All right, here are the questions. And just so it's clear, you do understand you're waiving and giving up your right to a trial by jury by your waiver of trial by jury documents you signed. Do you understand that?
Yes, sir.
Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
You understand everything you're doing here in court on Zoom today?
Yes, sir.
Have you been over everything you're doing here in court on Zoom, as well as all the facts of your case with your attorney, Mr. Cargill?
No, sir.
Let me ask you that again. I may have gone a little bit too fast. Have you gone over everything about the facts of your case, all these plea agreements, and everything you're doing in court today on your plea of guilty with your attorney, Mr. Cargill?
Oh, okay. Yes, sir.
Is he competent, Mr. Cargill?
He is, Your Honor.
Any else of incompetence, Officer?
No, Your Honor.
Board of States Council, signed her consent, approved the waiver of trial by jury, waiver of trial by jury is approved by the court. All right, now just sort of in summary on this one, Mr. Bordeaux, you do understand all the allegations, the charge in the indictment, your full range of sentencing, all the plea documents you signed or signed and sworn to, including your plea agreement for 7 deferred. Is that correct?
Yes, sir.
Have you any questions for me about anything?
No, sir.
All right, in calls number 241-0857-21, what is your plea today to the indictment charging you with the offense of robbery, a second-degree felony as alleged in the indictment? What is your plea to the indictment, like guilty or not guilty?
Guilty.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily because you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you in any way or promised you anything or coerced you, made you plead guilty?
No, sir.
And be sure you understand this now. Are you entering your plea of guilty to this indictment today freely, intelligently, knowingly, and voluntarily because you committed the offense charged in the indictment?
Yes, sir.
That's signed and sworn to admission by you for the record. That's the state's Exhibit 2 we talked about. Are you pleading guilty to the indictment because you have any delusion or some type unrealistic hope of parole or leniency?
No, sir.
All right, court receives and accepts your plea of guilty to the indictment. Mr. Bordeaux, what do you have, Ms. Alter?
We would offer States 1, the plea packet with signed waivers and admonishments, States 2, the signed and sworn to stipulation of evidence, as well as States 3, the discovery compliance documents.
Any objections, Mr. Cargill?
No objections, Your Honor.
All right, court admits into evidence States 1, all the plea papers, States 2, the signed and sworn to stipulation of evidence, written judicial confession to the offenses alleged in the indictment by the defendant, States 3, discovery compliance, all approved by the court. Court finding all the documents under these exhibit numbers were done by the defendant freely, intelligently, knowingly, and voluntarily. The court does further find that the defendant's plea of guilty entered to the indictment in the case, was entered by the defendant to the indictment in the case, and the offense charged in the indictment freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty to the indictment, charging him with robbery, a second-degree felony. However, the court does at this time withhold a finding of guilt to the defendant. Proceeding to sentencing, Ms. Hunter.
We would offer States 4, an electronic copy of the written discovery in this case.
No objection.
Those 4 is read to evidence without objection. Anything else, Mr. Cargill, at this point?
No, Your Honor, other than my client does desire to request a transfer to where he lives and works.
All right, I'll take that up just a minute, Mr. Cargill. Court the case then, having received and accepted the defendant's plea of guilty to the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily. Court informally pronouncing sentence, the court does find the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense of robbery, second-degree felony, as alleged in the indictment. However, the court does follow the plea agreement and the recommendation of the state. And the court assesses the sentence at 7 years deferred adjudicated probation, no fines assessed, court costs are ordered paid. Post-sentence is ordered to determine what amount of restitution, if any, is due. If any is determined to be due by the post-sentence, it's made a condition of the defendant's deferred adjudicated probation. The court formally pronounces this sentence, finds the evidence in the case fully sufficient to support the defendant's plea of guilt to the offense alleged in the indictment, withholds the finding of guilt, formally assesses sentence, 7 years deferred adjudicated probation, withholds the finding of guilt under all the terms and conditions assessed by the court, which are the standard conditions unless there's some recommendation to otherwise. Standard set of conditions for the offense of robbery. You understand, Mr. Bedeau, I'm now accepting from you through your attorney a waiver of your right to file a motion for new trial. Waiver means giving up. So you're giving up your right to file a motion for new trial, and you're giving up your right to appeal. Do you understand that?
Yes, sir, I do.
Are you giving up those rights freely, intelligently, knowingly, and voluntarily?
Yes, sir.
Court approves all plea documents, receives and accepts a waiver of appeal, waiver of right to file a motion for new trial. Court having followed the plea agreement and recommendation of the state, the court having assessed your sentence in 7 years deferred adjudicated probation. Mr. Bedeau, as I mentioned, deferred can go 2 ways. You successfully complete your deferred, do not violate any of the conditions of your deferred. Halfway through, you can file for an early termination of your deferred. That's up to the judge that hears it at that time. The judge can grant it or deny it. The judge denies it, you just stay on the deferred. Any violation of your deferred adjudicated probation at any kind, failing to report, failing a drug test, any of those 70 or so violations, that triggers a no bond warrant from the judge. Then when you turn yourself in or you're apprehended, there's a hearing before the judge. It's not a jury trial, it's before the judge. And if the judge finds you have violated one or more conditions of your deferred adjudicated probation for this offense, the judge can go back, finds you guilty of the offense of robbery, a second-degree felony, and because you're on deferred, the judge can give you up to the maximum 20 years to the Texas Department of Corrections Institutional Division, fine of up to $10,000. You understand all this, Mr. Bedeau?
Yes, sir.
Now, the court's probation officer, Marcella, is going to carefully explain to you what your number one condition of your deferred is, and that is how you go about and when you're supposed to report to the probation officer, to the probation office on each line, which she'll explain to you where you'll meet your supervising probation officer. Go ahead, Marcella.
Mr. Bedeau, immediately upon being released from Smith County Jail, report to the Smith County Probation Department. When you get to the probation department, sign in new from court. Our intake officer will come and get you from the lobby and you'll be assigned a supervision officer. If you're released today after 5 p.m., we'll see you at the probation department tomorrow by 8 o'clock in the morning.
You,
Okay.
you understand that, Mr. Bedeau?
Yes, sir, I do.
I happen to have a clock in front of me. I'm not sure you do. Probably not. But it's about 4:35. I have a clock sitting in front of me. So your odds of looking out and getting to the probation department today before 5 will be slim and none. So you're likely to book out at the earliest sometime after 5. Or you'll book out in the morning. Depends on how many they're trying to book out. Bottom line is, whenever you book out of jail, if it's going to be after 5 this evening, probation department will close at 5. Whenever you book out of jail, you have to report immediately to the probation department. There's already a supervising probation officer waiting for you, expecting you in the morning, and he or she will go over these 70 or so terms and conditions of your deferred. The first one being to report and being the probation officer at 8 o'clock in the morning. Do you understand that?
Yes, sir.
Here's the deal. Your supervising officer has already been appointed, and your supervising officer will look at a screen. Your supervising officer will know when you booked out of jail on the screen. So if it's sometime this evening, your supervising officer will know it, and then they'll be sitting there waiting for you at 8 o'clock in the morning. You follow me on all this?
Yes, sir.
This seems simple, but you would be surprised. Well, I don't know whether you'd be surprised or not. There's a lot of individuals, for one reason or another, they just do not timely report, and within a day, there's a no bond warrant out for them. Okay, and that can be used to adjudicate your probation, find you guilty, and assess your sentence in 20 years, up to 20 years by a judge. So I'm trying to emphasize to you the importance of reporting. You can't be supervised. You can't understand what you're supposed to do on your conditions unless you report. Your probation officer explains it all to you. Okay.
Yes, sir.
Let me tell you one other thing. When your probation officer goes down through and he or she will explain, it'll take a while, but you'll have the time. He or she will explain each of those 70 or so conditions, and they will say, do you understand this condition? If you say, yes, I do, or yes, I understand it, they're going to check a box that says you said, because you did, that you understand the condition. Later, if a warrant goes out alleging violations of one of those conditions, it's going to be too late to come in and say, well, I violated the condition, but I didn't understand it. In all likelihood, the judge won't bite. You with me?
Yes, sir.
What I'm emphasizing unto you is the reason when they go through those 70 or so conditions, listen closely. Don't just say yes, yes, yes. You don't understand, you tell them, and they'll spend whatever time necessary for you to understand the condition. I believe your attorney may have indicated you're gonna ask for a transfer of your supervision. Let me get that covered. That final decision will be made by your supervision officer. I don't know enough about you to know whether or not I would approve a transfer of your supervision to another county. If your probation officer recommends it, I'll approve it. But let me explain this to you. Some individuals get confused on this. Your case is not going anywhere. Your case stays here in this court. I don't know where you're gonna, let's just say you were asking for Picker County, Gregg County. Okay, if it's your supervision that's transferred, do you know the county you're gonna ask to be supervised in?
Yes, sir.
What county?
Anderson County.
Okay, well, that's Palestine. You could probably drive back and forth. You can probably get here from Palestine, Anderson County about the same time you can from way out south Tyler. But are you gonna be working in Palestine?
Yes, sir.
What are you gonna be doing?
I'll probably go to a warehouse, Walmart warehouse.
Okay, so obviously you're sitting in jail now, so you figure you're gonna be doing work in the warehouse, correct?
Yes, sir.
I mean, that's great, as long as you're employed. I'm gonna, the final decision is your probation officer. I'm not asking you all the questions. Unless there's some objection from your probation officer, if there is, Marcella will tell me. Unless your probation officer has some objection to you being supervised in Anderson County, I'll transfer the supervision to Anderson County, but the case stays here in Smith County. So if you violate and there's a motion to adjudicate with a no bond warrant, it'll be the judge of this court that will hear it and hear evidence on the violation if the state proves one, not a judge in Anderson County. I've had some probationers get mixed up on that. Do you follow me?
Yes, sir.
You have any questions for me about anything?
No, sir.
Okay, 8 o'clock in the morning, you're gonna be where?
At Smith County supervision. The
Probation office.
Yes, sir.
You know where it is?
Yes, sir. I do.
Okay. Anything else, Mr. Cargill?
No, Your Honor.
I don't know anything else to tell you. Mr. Bedell, you know you're looking up to 20 if you violate. If you're successful on your probation, you'll end up with state dismissing the case. Anything else, Marcel?
Nothing further, Your Honor. Oh, Your Honor, he's not to have any contact with the victim in this case.
Oh, but your probation officer will explain that to you. There's no use in me reading the victim in the indictment into the record, the name into the record, but your probation officer will go over the victim's name with you, and it's going to be one of your conditions of your deferred that you cannot have any contact, direct or indirect, with the victim alleged in the indictment. Your probation officer will be sure you know who that is. As a matter of fact, reading the indictment, you probably know who it is, don't you?
Yes, sir.
Okay, I thought you did once I read on down through the indictment. So there'll be no contact with that victim. And let me explain this to you on no contact. No contact means you cannot go anywhere that the victim is. I'm not going to read her name in the record, no reason to. You cannot go anywhere where that victim is working, residing. You cannot go within 1,000 feet of her person. Are you with me on that?
Yes, sir.
Here's the other part now with all these electronic devices. You cannot have any contact with that victim by any of these electronic means. Twitter, Facebook, texting. You follow me on that?
Yes, sir.
Okay, I mean, that's pretty easy to prove if you text the victim, Twitter the victim, or any of these electronic devices. If she reports you to the probation department and likely reading the allegations in the indictment, she would. And then that contact with her, any of those electronic means will be a violation of your probation. I'm cautioning you about that because I don't know anything about the facts of the case. You don't have a pre-sentence. I don't know whether you know the victim personally related to her or not related, but my guess is you probably know her. So you know who I'm talking about, right?
Yes, sir.
Okay. That's about it for me, Mr. Cargill. You have anything else?
No, Your Honor.
Anything else, Ms. Oxford?
No, Your Honor.
All right, Mr. Bordeaux, they'll see you, it'll be after 5. They'll see you at 8 o'clock in the morning at the probation department. Do you understand everything we've been over, Mr. Bordeaux?
Yes, sir.
All right.